Act says that you can't patent a second medicinal use for an already known compound, or rather a compound that was already known for a first medicinal use. Now, even this provision is not exceptional, because a similar provision existed in Europe until quite recently, I think until the 1990s, when an enlarged board of the European Board of Patent Appeals in the SI case actually held that a second medicinal use was patentable, provided that you drafted the claim in a certain way that was directed to the pharmaceutical composition rather than directly to the medicinal use itself. So there's nothing exceptional about a provision which says that a second medicinal use of a compound is not patentable. Section 3D, I do agree, is a fairly exceptional provision. Its parallel does not seem to exist in the patent law of any other jurisdiction, at least that I have examined. But there, and of course the exceptions which are, the items which are mentioned under Section 3D, polymers and formulations or whatever they may be, isomers, these are often judged in other jurisdictions on grounds of patentability. Now, a polymorph may or may not be patentable. An isomer may or may not be patentable. But at least at one point of time in US law itself, isomers were considered to be prima facie unpatentable unless you could actually demonstrate an unexpected property with respect to the closest prior art, which was more often than not the corresponding racemic compound. So there were certain inbuilt, if you like, jurisprudential safeguards in US law, which actually dictated when you could not get a patent to an isomer. But there was no blanket rule. Section 3D does appear to be a blanket rule, but of course there is also the rider that if the patentee is able to demonstrate efficacy, then the patent can be granted notwithstanding Section 3D. So there is an exception to Section 3D as well. Now, coming back to what I was discussing before this, which is whether the existence of product patents is likely to actually prove a deterrence, if you like, to generic companies. And this is quite interesting. It certainly does seem to have affected the mindset of generic companies in general. I mean, if there is, for example, in India, a product patent which will not expire before 2020, then you will rarely see the management of a generic company leaping at the chance of trying to launch that product before 2020. I'm not quite sure why this is so, because the Indian courts where some of these cases have been tested out do appear to be quite favorable or, if you like, anti-patent, but that's probably not the right way of, not the correct political way of putting it. But they do seem to, strain to find grounds to actually invalidate a patent in court. So the experience in courts, what I'm trying to say, has been by and large favorable to generic companies. So it's not, I'm not quite sure why generic companies should take the stand that they will not attempt to either launch or develop a product in the face of a product patent. There are different, again, theories. Different people have different theories. Some people would like to clear the way first before entering the market, which means filing a revocation or an opposition. Some people might like to launch the product directly onto the market and then invite suit for infringement. And then when the suit for infringement comes, counterclaim that the patent is invalid. So there are all sorts of approaches. But certainly the existence of product patents in India has made an important impact on the mindset. I would call it the emergence of a more IP or patent sensitive culture, because you simply do not do that in most countries. You simply cannot launch your products if there is an existing valid patent without actually having to challenge the patent. Of course, the US is a jurisdiction which actually gives you the freedom to commit an act of infringement through the filing of an ANDA application and yet not incur damages for lost profits because of the amendments made by the Hatch-Waxman Act. But that is, again, a very exceptional jurisdiction. In most countries, if you want to test out the patent, you must launch your product. And only when the infringer sues you for infringement, then can the court determine whether the patent is valid or not. India is one of those jurisdictions. Now, if you look at the patent litigation that has occurred so far in the regular courts, I'm not talking about the patent office. It's my view that, the decisions of the patent office are far more balanced than the very few decisions that have come out of the regular courts in India so far. And if you look at those litigations, then you'll find that quite a few of them actually relate to the so-called compound patents. And while I'm not sure that we've had an actual conclusive decision in any one of them, I think that there have been a couple of interim decisions where judges have gone into the merits of whether a compound patent was actually should have been granted in the first place or not. And you will see a certain tilt towards a law of obviousness that is quite broad if you compare it with the way that the concept is applied in other countries, for example. So, and the other thing that probably influences the decision maker's mindset is what kind of product is it? I mean, if it was a pill for curing headache, would you have had such a strong reaction from the court? But most of these cases I've actually been dealing with anti-cancer drugs, and which is obviously a life-threatening kind of a disease. So any medication useful to treat that kind of an indication will always be very sensitive in terms of the IP rights that surround the product. So I do think that decisions are partly flavored by the category of product that is actually constituting the act of infringement. But we'll have to see when more mundane products come before the courts, whether the same story will continue or not. Now, the other thing is that obviously it's something we've discussed before, and I don't want to raise it because Mr. Dressel is looking at me.
And not because of that.
And I don't want to put ideas into his head.
No, continue.
Is the act of manufacturing itself. Because let's face it, the patent battles between generics and innovators have now become global battles. They are not limited to one country. They're spread across many different countries. So if there's a high-stakes battle being fought out in the US, its repercussions will be felt in the Indian courts. And why is that? That's because the product is actually being manufactured in this country. But no one has actually given me a satisfactory answer as to why companies are not being sued for the act of manufacturing products in India. I can think of a couple of reasons. The first is that, like most other countries, the Indian Patent Act provides a BOLA provision. The BOLA provision makes it not an act of infringement to manufacture a product for the purposes of approval. Now, unlike the US BOLA provision, which only safeguards you in respect of a US FDA filing, the Indian BOLA provision is wider. The Indian BOLA provision actually safeguards a company if it is intending to apply for approval anywhere in the world. That's the reason why it's a little broader than the US BOLA provision. And most of the manufacturing of a product that takes place at R&D stage can probably be directly linked to the Bollard provision. It's when you come to commercial scale up that you could possibly have an act of infringement. But by the time you come to commercial scale up, the product is ready for launch, say in the US. Now, if you look at the timelines of patent expiry in the US and in India, the US has a specific provision, again introduced by the Hatch-Waxman Act, only in respect of pharmaceutical patents, of a patent term extension, which can go to a maximum of 5 years. Whereas the Indian Patent Act has no similar provision. Therefore, it's quite possible that a lot of the patents will expire earlier in India than they do in the United States. But of course, even under US law, the PTE or the extension can only be sought for one patent that covers the product. And that is more often than not likely to be the molecule or the product patent. This, of course, this logic does not, of course, apply to all the subsequently expiring patents, including any method of use patents or formulation patents that might exist in the Orange Book. So it's quite conceivable. And then the second possibility is that a US court actually invalidates a patent that is still valid in India simply because it has not yet been litigated. But if after a US court has invalidated a patent in the United States, that will, in my observation, will likely influence the mind of a decision maker in India as well, because the grounds which a US court are likely to use in invalidating a patent are likely to be strong grounds. So therefore, conceivably you could use the same grounds to invalidate the equivalent of that patent in India. So all the possibilities that could possibly arise under the new system, given the fact that now not only innovator companies are global, but also generic companies are going global. And the fact that, it's no longer a question of a patent battle in the US being restricted to the US or a patent battle in Europe being restricted to Europe. People are likely to hit each other or strike each other wherever they can, in whichever country they can. So, things, I think, going forward are going to become a lot more interesting for people in our profession. And that's a good thing. Thank you.